your take that you would like to have someone that you're having a sexual relationship with in your home overnight, specifically while you're in possession of your infant child and your 5-year-old son.
And I'll take testimony. Ma'am, can you please state your full name?
Pamela Tellez.
Ms. Tellez, did you hear the terms that I read as agreements?
Yes, ma'am.
Are those terms still your agreement?
Yes, ma'am.
And do you believe that those terms are in the best interest of your children?
Yes, ma'am.
And are you asking the court to accept those terms?
Yes, ma'am.
Now, let's discuss the issues that you did not agree to. Are you requesting a non-disclosure of your address?
I am not.
And do you understand that the father is requesting a non-disclosure of his address?
Yes.
Are you in agreement to that?
No.
Can you explain why you're not in agreement for non-disclosure?
I'd like to know where my kids are. I don't know if that's a crazy request whenever they're not with me, where they reside, where they're sleeping.
Okay. Are you in agreement for the father to have the state standard possession, which is Friday through Sunday, first, third, and fifth weekends of the month?
Yes, ma'am.
You're in agreement?
Yes, ma'am.
Okay. Are you requesting rights of first refusal?
Yes.
Are you requesting an injunction for Mr. Morales to have partners in the house between 9 p.m. and 6 p.m. during his visitation time?
Yes.
Let's talk about retroactive child support. When did you and Mr. Morales stop living together?
We lived together for 2 months last year, October and December. So he moved out December 2024.
Based on the information, the state calculated retroactive child support at $5,878 and $5,878 to be repaid at $80 a month starting November 1st, 2025. Are you in agreement to that?
Yes, ma'am.
During that time, did Mr. Morales give you financial assistance to take care of the children in any amount?
Right out of the gate, this courtroom tension is already thick. We're not easing into this case. We're diving straight into one of the most emotionally charged issues in family law. Overnight partners and young children. An infant, a 4-year-old, 2 unmarried parents, and a judge who is not here for theatrics. This is a Texas custody battle unfolding under the framework of the Texas Family Code, where best interest of the child is the golden rule. But here's where it gets interesting. Both parents are partially agreeing, partially disagreeing, and walking a tightrope between control and cooperation. There's no family violence, no criminal allegations, just 2 adults who broke up less than a year ago, and now they're fighting over structure, morality clauses, money, and power.
And I pass the witness, Your Honor.
Yes, ma'am. Ms. McLean, go ahead.
Ms. Tellez, can you please state your children's age?
Levi Morales, he's 4, and Camila Morales, she turned 7 months yesterday.
And for your 5-year-old son, how often does the father pick the child up for possession?
He's 4 and he picks him up. So right now he's with him every other Thursday after school until drop off Tuesday, and then picks him up on Thursdays on his off weeks.
Okay. Are you looking for something that is a little bit more refined and structured and sustainable as the child grows in age?
Yes, ma'am.
So to clarify, you are in agreement for your son to have a standard possession schedule according to the Texas Family Code, not for your daughter,
just my
correct?
son. Yes, ma'am.
Okay. You two stopped living together before your daughter was even born, correct?
Yes, ma'am.
You last lived together in December of 2024?
Yes, ma'am.
And isn't it true that Mr. Morales has never had overnight possession of your daughter who's currently an infant?
Correct.
Are you asking the court to order a stair-step possession today until your child reaches the age of 3 and she can start standard possession with her brother?
Yes, ma'am.
Are you asking the court to order that step 1B until the child turns 9 months and that he has possession Tuesdays from 6 to 8 and Saturdays from 10 to noon
Yes, ma'am.
at your home?
Yes, ma'am.
Are you asking that step 2B from the child's age from 9 months to 1 year old, that it be the same schedule, but that he could then have possession outside of your home?
Yes, ma'am.
And for step 3, beginning at age 1 to 2, that it turns into an overnight beginning Saturday at 10 a.m. to Sunday at 10 a.m. on first, third, and fifth weekends.
Yes, ma'am.
And that step 4 be from ages 2 to 3, and then it'd be from Friday at 6 p.m. to Sunday at 6 p.m. first, third, and fifth weekends.
Yes, ma'am.
And that at age 3, then your daughter will begin a standard possession schedule.
Yes, ma'am.
And let me rephrase. Why do you think it's in your children's best interest? Let's go to the injunctions part. Why do you think it's in your children's best interest for that neither of you to have an overnight intimate partner until your youngest child turns 6?
For their sole protection.
Do you want to elaborate?
Just being able, especially our smallest one, still not being verbal or needing.
Notice how calm and procedural this feels right now. Miss Teasy is answering clearly, respectfully, and without hesitation. That matters. In family court, tone is everything. Judges are constantly evaluating credibility. Not just what you're asking for, but how you're asking for it. She's framing everything around best interest of the children. That phrase is not accidental. Under Texas law, that's the legal standard. Every request, whether it's scheduling, injunctions, or passport control, has to orbit that principle. What's interesting is she's agreeing to standard possession for the older child, but not for the infant daughter. That's strategic. Courts often use step-up schedules for infants. She's not trying to block the father. She's asking for gradual transitions.
Yes, ma'am.
Would you like to know where your extremely young child and your son is when they are with their father?
Absolutely, yes, ma'am.
I pass this witness.
Okay,
I'm sorry. One more question, Your Honor.
Oh, yes, ma'am.
I'm sorry. For the right of first refusal, why do you think it's in the best interest of the children that if either one of you are unable to care for the child for 6 hours or more, that a parent has the opportunity to have possession before you go to a non-parent?
It seems fair to me that if he's unavailable and I am, that I get to have them back, and vice versa. If he's available and I have something that I need to attend to, then he would be able to spend that time with them.
And this is only if it's 6 hours or more, correct?
Yes, ma'am.
So if it's 1, 2 hours, 4 hours, then that's fine. But if it's 6 hours or more, you are asking that you at least give each other the right of first refusal before going to a family member, a babysitter, etc.
Yes, ma'am.
Do you think that's in the best interest of your children?
Yes.
Do you believe that all of your requests today are not just reasonable, but in the best interest of your children?
Yes, ma'am.
I pass this witness.
Okay. Remember, that's for you.
Thank you. Mr. Morales, can you please state your full name?
It's Alejandro Morales.
And Mr. Morales, did you hear the terms that I read earlier as agreements?
Yes, ma'am.
Were those terms still your agreements?
Yes, ma'am.
And do you believe those terms are in the best interest of your children?
Yes, ma'am.
And are you asking the court to accept those earlier agreements?
Wait, I'm sorry. The original agreements that you stated before, not what was just discussed?
Just the
Okay, just
agreed
the first.
terms.
Okay, those are, yes, the ones that we mutually agreed on. Yes, ma'am.
Yes, and you're asking the court to, excuse me, accept those terms.
Yes.
Sorry. Let's talk about the terms that we did not agree to, okay?
Yes, ma'am.
You are requesting a non-disclosure of your address, is that correct?
We can rebuttal on that. I'm fine giving the address.
Okay, so
So,
you're fine with your address and phone number being in today's order?
yes, that's fine.
Thank you. And you are requesting a standard possession, is that correct?
No, ma'am. I'm actually rejecting this standard just based off of the last 2 years and then some.
Objection non-responsive after yes.
Sustained.
Okay, so, sir, just to be clear, you are not in agreement with the state standard possession.
No, ma'am.
Here we go. Retroactive child support. And this is where custody hearings often turn from cooperative to confrontational. The state calculated $5,878 owed. That number isn't random. It's formula-based. But here's the twist. She acknowledges he paid daycare directly and sent $1,500. Yet when asked if she would credit that $1,500 against the total, she says no, because from a legal standpoint, daycare payments are financial support. And when one party appears unwilling to credit documented assistance, it can shift how reasonable they appear in the court's eyes.
You said you're not in agreement for the state standard possession. What kind of visitation schedule are you requesting for both children?
I would like to keep the schedule we currently have. It's pretty significant. So she had mentioned she did miss one portion. So I do pick him up from Thursday and keep him overnight through Tuesday drop-off. But I do pick him up most every other Tuesday that I don't have him that weekend, and Thursdays. So every Tuesday and Thursday, the only time I don't pick up is if I just had that weekend with him.
Okay. So you want to keep the Thursday through Tuesday schedule that you currently have?
Plus that Tuesday evening, every other.
Every other Tuesday evening?
Yes, ma'am.
And that's for both children?
Ideally, yes. I do understand that we need to do kind of a step cadence for Camila.
Okay. You understand that the mother is requesting retroactive child support?
I am aware, yes, ma'am.
Okay. And the state calculated $5,878 to be repaid at $80 a month beginning November 1st, 2025. Are you in agreement to that?
No, ma'am.
Okay. How much would you state that you have given in financial support to the mother?
Between the daycare and insurance that had been paid was $9,662.61. $9,662.61.
So you are asking that no retroactive child support be granted in this case, is that correct?
Yes, ma'am.
Okay. As far as the injunctions requested, are you in agreement to having an injunction against an overnight partner in the house between 9 p.m. and 6 a.m.?
I do not agree to that.
You're not in agreement. Okay. And the other issue, the right of first refusal, are you in agreement to that as well?
I misunderstood initially. I do agree. That's fine. Because initially I thought, even if it was 1 or 2 hours, that we would have to pass to each other. And in those cases, I disagree. But yeah, if it's 6+ hours, it makes sense.
Okay. I pass the witness, Your Honor.
Ms. McCain.
Thank you, Your Honor. You understand that you currently have no court that allows for holidays or summer possession, and that Ms. Tellez offering you standard.
This is actually a textbook step-up proposal. For infants, courts often prefer gradual expansion of visitation. Short visits, then longer visits, then overnights. It's developmentally sensitive and legally sound. What strengthens her position is that she's not denying access. She's mapping out a timeline. Supervised feeling visits in her home, then independent daytime visits, then structured overnights, and eventually standard possession at age 3. But here's the subtle tension. The father claims he hasn't had overnights not because he refused, but because he wasn't permitted. That's a very different narrative. If the judge believes he was excluded rather than uninvolved, sympathy may shift.
The conversation, but
The injunction,
no, that's not the intent.
The injunction states intimate partners.
Intimate can be a broad range of meaning. It doesn't have to be physically intimate. I mean, you can hug your cousin. I mean,
so are you aware that per case law, that intimate partners would be a non-relative, so not a cousin. It would be someone that you would be in a dating relationship with, is defined as an intimate partner.
Okay, understood.
So is it your take that you would like to have someone that you're having a sexual relationship with in your home overnight, specifically while you're in possession of your infant child and your 5-year-old son?
No, I would.
Objection not responsive after no.
Sustained.
I pass this witness.
Okay. Ms. Latifi, anything else?
No, Your Honor. State rests.
Ms. McLean, I just had a question, if you could answer for me. These two parents are not married, correct?
Correct.
Okay. All right, give me just a minute. Ms. Diaz, is your 4-year-old in school yet or not yet?
He is at Primrose Preschool, so it's a daycare. It's not like public.
Okay. I got you. Ms. Latifi, I forgot we had a long hair here. What was the exchange location? Was it the daycare or was it somewhere else?
It was Walmart. I
Change
think.
location was at a Walmart. The location was 1213 East Trinity Mills, Carrollton, Texas,
Okay.
75076.
Okay. All right. Let me go through the parts y'all agreed to. Making a finding there's been no family violence. I'm not sure about the exchange location. I may need to change that, but okay. So for communication, y'all want to do app close to communicate?
He's not agreeing to retroactive support, and he immediately counters with a much larger number. Over $9,000 in claimed financial contributions. That a dramatic contrast to the state's calculation. This is classic dispute framing. One side says you owe, the other says, I already paid. The credibility battle is subtle here. He calmly explains payments for daycare and insurance. He's not denying responsibility. He's disputing the math. Notice his composure. He corrects misunderstandings. He clarifies visitation frequency. He objects when necessary, but doesn't escalate emotionally. The judge is now weighing two competing narratives: underpaid support versus substantial undocumented assistance. And she's about to make that clear.
To be paid each month beginning November 1st. Medical support is $226 per month with mother to carry insurance. Make sure you give a copy of the card to Mr. Morales as soon as possible so that he can have it in case of an emergency. Mr. Morales agrees to pay the court costs, and mother is to have the exclusive right to apply and retain the child's passport. Y'all agreed to there be no non-disclosure, so both of you are obligated to provide each other your current residence address of where you live, where you know, not your mailing address, but your residence address. I think y'all have agreed on the right of first refusal over 6 hours, but you know, obviously within reason. Okay, so here good to the contested issues. If Mr. Morales has been paying daycare and he gave you $1,500, I don't know why we're asking for back child support. The daycare was essentially child support in some way. I don't understand why at the very least you wouldn't want to credit him with $1,500. That doesn't sound very reasonable. It's not request, so I'm just not granting any back child support. Y'all didn't have any orders before. It looks like y'all did the best you could to figure it out, and Mr. Morales did help. It's not my typical case where someone hasn't helped at all. Maybe the argument is didn't help enough, but that's arguable for both of you. Y'all are unmarried. Y'all have been sleeping with each other in your home with your children. I don't understand why y'all need an injunction now just because y'all broke up and now it's all of a sudden offensive. It doesn't make sense to me. If y'all were married, that would be common that maybe you wouldn't sleep with someone else. That's usually a pretty common thing that people ask when you're married, but you're not married. So y'all have been doing exactly what you don't want to have happen. I don't understand why that request is being made. Obviously within some reason, of course, but y'all are going to move on and you're going to have new boyfriends, new girlfriends, and they're going to be part of each other's lives, and they're going to be part of your child's lives. That's what y'all kind of decided first when y'all got together and dated and were.
The judge reframes the injunction issue in blunt terms. Various sexual partners. That wording is powerful. It shifts the conversation from legal technicalities to moral implications. But the father pushes back on language, clarifying that intimate partner is broad and doesn't necessarily imply sexual conduct in front of children. That's not defiance. That's semantic precision. That response neutralizes a potential moral red flag. Had he insisted on unrestricted overnight partners, the optics could have turned sharply against him. Instead, he avoids appearing reckless.
Females or males be excluded during time of possession. That doesn't make any sense based on what's the history of this case. As far as visitation is concerned, I know we have one young child. I'm kind of sensitive to that, but I don't understand why we haven't had any visitation before today. I don't know if that was related to y'all breaking up and someone saying, well, I'm not going to let you visit as a punishment for breaking up with you. I don't know. I didn't get that information. I'm just talking out loud, but we should have had visitation before this with the 7-month-old.
Your Honor, just to be clear, he's had visitation with the 7-month-old. He's just never had overnights with the 7-month-old. He has access to the child.
Okay, then why are we asking for supervised visitation?
It's just as consistent of what he's been doing. He's been going to mom's house to see the baby. So that's the only reason why we put that as step 1, because that's what he was already doing. So we were asking to continue that until she turned 9 months, and then he would just start having her on his own.
But they don't like each other. Why would he want to go to her house for 3 or 4 hours in her house to visit the child?
That's what they were doing before this case started. So that's the only reason why I put that as step 1, because that's what they were already doing.
Well, what power does he have to object to that? If he decided, no, I want to take the child out of the home, you saying Ms. Diaz was going to let him take the child out if he had asked?
I'm not sure. I'm not there.
May I speak?
I mean, I know what the answer is. We've been doing the best they could to figure it out, and I don't understand. Okay, let me just a sec. I guess a little house cleaning on this. I need to know, is the 7-month-old going to daycare?
She has a nanny here at home.
Okay. You said, Mr. Morales, you're able to pick up your son from school on Thursday afternoon and take him to school on Monday morning?
She openly questions the fairness of requesting retroactive child support when daycare was being paid and money was sent. That is judicial skepticism, and it's not subtle. She even states it doesn't sound very reasonable not to credit the $1,500. That language matters. Judges rarely use that phrasing unless they're signaling dissatisfaction. Then comes a ruling. No retroactive child support granted. The judge frames it as both parties doing the best they could without prior orders. She acknowledges he helped, maybe not perfectly, but not negligently either. This reinforces something critical in custody cases. Court's reward demonstrated effort, even imperfect effort. She essentially says, you weren't married, you're already cohabitating, and now that you've broken up, the moral standard hasn't suddenly changed. Without family violence or safety concerns, she doesn't see the need for a morality injunction. The court prioritized practicality over emotion. No punishment, no moral lecturing, just structure. This case highlights something crucial. Family court is less about who feels wronged and more about what's reasonable, documented, and child-focused. If you found this case as revealing as we did, hit that like button. Share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns.